Hi, and welcome back to Military Law Talks. So, today's video is about the DoD's transgender troop ban. So, I've done videos about this in the past, and I actually filmed a video on Thursday discussing the Supreme Court's stay of an injunction in one of these cases. Now, I didn't release that video yet because within an hour of me filming that video, of course, the DoD issued more policy, different policy. And so I decided I wanted to do a second video to fully explain it. So I'm releasing both those videos at the same time. So if you haven't watched part one, watch part one, and this is part two. So, like I said, I've been following these cases. So, to do a little review, the Trump administration is essentially reversing a policy from the Biden administration that allowed soldiers or service members with gender dysphoria to serve openly and to gender transition while they're in the military. Now, kind of if we go even further back, so the Obama administration first actually allowed this, then the Trump administration 1.0 reversed the policy, and then the Biden administration reversed that. And then now Trump administration, Trump 2.0, has reverted back to essentially saying that gender dysphoria is a medically disqualifying diagnosis. And so individuals with gender dysphoria can no longer serve in the military and cannot assess into the military. And so while I explained in part one that the US Supreme Court recently issued a stay of an injunction, and that injunction stopped the DoD from implementing this reverse policy. And so it essentially just reverted back to like Biden administration. Transgender soldiers, individuals with gender dysphoria could continue serving, and essentially stopped the Trump administration from voluntarily or involuntarily separating those service members. And so that stay was for that Washington state. So there's a couple federal cases out there challenging this policy, and one of them is in Washington state, another is in Washington D.C., and then there's a third case, but that injunction only applied to the parties to that case, and that one is still in place. And so part one of this video series, the one that I'm releasing today, it discussed the stay in the Washington case. And I explained in that video, well, there's still a nationwide injunction in the Washington, D.C. case, the Talbot case. And so that's what I'm going to cover in this case. And I'm actually glad that I kind of displayed tactical patience, which unfortunately the Trump administration is not doing, and I think they could benefit from. And so there were some extra filings in that case on Friday. So I am filming this on a Saturday to go over those additional filings that were filed in the Talbot case this week, post Supreme Court stay in that other case. Okay, so let's get into it. Okay, so this is the docket for the Talbot case that is currently pending in the DC Circuit Court, the Court of Appeals for the DC Circuit. And so it was first filed back in April 10th after the district court issued that injunction. And there were oral arguments on April 22nd in front of Judges Pilliard, Kattis, and Rao. I'm probably not saying them correctly, but close enough. So I looked up these judges just a little bit. So Judge Pilliard is a female judge. She is an Obama appointee. Judge Kattis is a male judge. He's a Trump appointee, and he clerked for Justice Clarence Thomas. Judge Rao is a female. She's a Trump appointee and also clerked for Justice Thomas. So, I mean, take what you will, a little bit about their backgrounds. They're all like Ivy League grads. So they all either went to like Yale, Harvard, or a combination thereof. And so who knows? Maybe it's a favorable panel to the Trump administration, but maybe not. It's kind of a little interesting that oral arguments were, more than 2 weeks ago, almost 3 weeks ago, and they still haven't issued an opinion. And so after oral arguments, there's been more information filed in this case. And so they filed these letters. And so we're going to go over that. So first, after the Supreme Court issued the stay, the DOJ issued to the court in this case, right? They're explaining there's more information since oral argument. So they want the court to be aware of this additional information, saying that that stay in the Washington case, the Schilling case, had been issued by the U.S. Supreme Court. And so they want, hey, make sure, you follow the U.S. Supreme Court and issue a stay in this case too. I mean, they don't make that clear, but that's essentially what they're trying to say. So then the opposite party, so representing the plaintiffs in this case, issued a response discussing the U.S. Supreme Court stay in the Schilling case and explaining, hey, this case is different. So they said, yes, while they're somewhat similar, they're injunctions for the same policy. In this case, our case is a little different because the judge at the district court level found that there's discriminatory animus, made that specific finding, and that wasn't present in the Washington case. So they're saying, hey, it's kind of different. So, keep the injunction in place. And then pointed out that there's been some recent statements made that actually say that kind of like lends credence to their argument that this ban was motivated by anti-transgender animus, not by medical considerations. And so they talk about this tweet by Secretary Hegseth and a public statement, and this tweet by the DoD Rapid Response. It says, the tweet reads, at SecDef, we are leaving wokeness and weakness behind. No more pronouns, no more climate change obsessions, no more emergency vaccinations or emergency vaccination mandates, no more dudes in dresses. We are done with that. SHIT. And then I also have the tweet. So let me find that. Oh, bear with me. Okay, I found it. So this is the tweet that the plaintiffs were referring to that shows this animus, this discriminatory animus against transgender individuals by Pete Hegseth. So it says, the tweet is from SecDef's account, and it says, after a SCOTUS victory for POTUS, trans is out at the DOD, obviously referring to that Schilling case, the stay. So let's listen to the video.
Here at the Defense Department, we continue to relentlessly pursue the president's agenda, especially on readiness. He put out an executive order a week into his presidency, stating the prioritizing military excellence and readiness, that expressing a false gender identity divergent from an individual's sex cannot satisfy the rigorous standards necessary for military service. We agree, and so we implemented that policy. It was challenged in court, and of course, we appealed. And 2 days ago at the Supreme Court, our policy was upheld. And so we're going to continue to advance that policy here at the Defense Department. So in accordance with policy now reinstated, service members who have a current diagnosis or history of or exhibit symptoms consistent with gender dysphoria may elect to separate voluntarily. There's a timeline here, and then eventually involuntarily if necessary. This is the president's agenda. This is what the American people voted for, and we're going to continue to relentlessly pursue it.
Okay, so I don't envy the DOJ employees who will have to defend Pete Hegseth's video, new policy change without waiting on the DC Circuit to get clear guidance that they can move forward with the policy. And so again, I think tactical patience would really, really, really do this administration well, but they don't seem to be doing that. And so things that I want to point out in this video, he says that the Supreme Court upheld their policy. That's not what happened. The Supreme Court just issued a stay of the injunction, and then the case is still pending down at the district court level in Washington to actually like fully litigate the case. And then it's going to have to work its way up the Supreme Courts, because I'm pretty sure that the Washington court is going to rule against the Trump administration. And so kind of in the meantime, and the reason for the injunction is these service members are kind of in limbo. Can they stay in? Can they not? Can they stay in? And so the DOJ, or sorry, the Department of Defense put out the same day that that video was released, this was on Thursday, put out a new policy. So let's go over that policy. Okay, so this is the policy that was put out on May 8th, the same day as that video that we just watched of Pete Hegseth. So it was put out together, and it's the essentially reinstating the previous policies that were put in place that were on hold from the injunction. And it cites the Schilling case. It says that they're going to put these policies back in place, and saying that down at the bottom that service members with gender dysphoria may elect to separate voluntarily. So if they separate voluntarily, they can get separation pay, and that's extended to June 6th. And then for active component, and July 7th for reserve component. And then it says that those like we can do voluntary separations, and then the military will initiate involuntary separations after the conclusion of the voluntary separation window. So I think similar to what they're doing with DoD civilian employees is allowing people to self-select and leave voluntarily before implementing involuntary measures. And so that's what the administration, I guess that's how they're handling transgender soldiers or service members right now. And so, of course, this was issued as part of the plaintiffs, another letter. So this was issued on Friday to the court in the DC Circuit that's still pending that appeal for the preliminary injunction. And so, and saying that, hey, this is like further evidence of this discriminatory animus, not only this policy, but also the statements that the SecDef made in that video that we just watched. And then the government responded same day, Friday, May 9th, and talks about responding to the letter, explaining that, that we have this stay in the Schilling case, and it allows service members to voluntarily leave the service, and involuntarily would not initiate until after that voluntary separation window is open. And so it's saying that, hey, there's no discriminatory animus, and these are just part of the policy. And also citing that, hey, this policy shouldn't be subject to a nationwide injunction. And so further making that argument. So we'll see what happens. I'm going to take this down. We'll see what happens in these cases. I'm going to be following these cases on this channel. So like I said, I think the Trump administration has pulled a pretty favorable panel. Those 3 judges on the DC Circuit probably maybe a favorable panel, but it's a little telling that they haven't issued a order or either a stay or allowing the injunction to stay in place 20 days plus after oral argument. So it's kind of interesting. So we'll see what happens. So like I said, I'll keep following these cases on this channel. Please like this video, share this video out there, and subscribe to my channel if you haven't already. I'm a new channel. Help me grow, help me get the message out there. And thanks for tuning in. I'll see you in the next video.